myself Diksha Verma from BBLLB Cyber Law. This is my video presentation submission for Code of Civil Procedure for the academic year 2022. I am going to present on prerequisites to be followed when issuing summon to the witness. So the first one is, what is summons? A summon is a written notice served on a person under the authority of the court to appear personally before the court. Summon in Civil Procedure Code 1908 are served on the defendant and the witnesses. Defendant are summoned to intimate the suit filed against them, whereas the witnesses are summoned to demand evidence or to produce document or both. The concept of summons emanates from the natural justice principle of audi altrum partem, which says, hear both sides. Only those such summons the defendant became aware of proceeding against them. In the later stage of the suit, the parties can prove their cases with the help of witnesses. To bring such witness to the court, the parties seek the court's support. Thus, summons are sent to witnesses, though the procedure laid under the Order 16 of CPC. Without summons, the parties cannot enforce the presence of witnesses and establish their case. Buffet of such process, the attendance of witnesses cannot be achieved, thereby the dispute cannot be resolved on merits. So the second one is, who cannot be summoned. So according to the Code of Civil Procedure, certain people cannot be summoned to appear in person. So it would be made sure that the summon is not served to the such people. According to Rule 19 of the Order 16, the court cannot serve summon to person who is residing outside the original jurisdiction of the court. The rule is exempted if such person's residence is situated less than 50 miles from the courtroom, and even in the case where the person's residence is situated less than 200 miles from the courtroom, where there is an unavailability of public transport. Apart from this, women according to certain custom who do not appear in public cannot be summoned to appear in person before a court, nor arrested under Section 132 of Code of Civil Procedure. Section 133 exempt person holding constitutional position from personal appearance in the court, so they cannot be summoned by the court either. List of witnesses. Order 16 Rule 1 of CPC stipulates that the list of witnesses has to be submitted to the court by the parties. Such a list consisting of witnesses has to state details such as whether the witnesses are summoned for giving evidence or to produce document or both. This list has to be submitted within the 15 days from the date on which the issues are framed. The entire summon process itself is not mandatory under the Code of Civil Procedure. A witness can also be produced before the court without the name in the witness list or even without the summon under Rule 1A of Order 16. This is used in cases where the party does not require the court's help in bringing a witness to the court. So, only when the party is unable to bring the witness by himself, the court's help is sought and summon is sent. Under Rule 14 of Order 16, the court may also summon a witness suo motu if the court feels it is necessary to serve justice. The court can examine such witness on its discretion and it may require such a person to produce any evidence or to produce document as he can. Essentials in a summon. As per Order 5 of Rule 1, the basic necessity in any summon is the sign of the judge and the seal of the court issuing the summon. With respect to the summon to the witnesses, Rule 5 of Order 16 states that particular such a date and time at which the witness is required to attend are to be specified. Along with this, the reason for the procurement of attendance of witnesses, such as to give evidence or to produce a document or both, should be also mentioned in the summon. If the witness is called for producing any document, the name and description of the document is required should be mentioned in the summon. Summon outside the court's jurisdiction. The court cannot summon a person residing outside its own jurisdiction. In that case, Order 5 of Rule 21 provides that the court may issue the summon to the court having the jurisdiction over the person's residence. though its officer, or by the other means such as by post, by electronic mail services. Then Rule 23 enables such as the code to which the summon is sent to the server to the summon. According to Section 31 of Code of Civil Procedure, Section 27, 28 and 29 can also apply in the case of summon to witnesses. Wherein Section 28 in service of summon outside the state states that the summon has to be sent to the court with jurisdiction in the other state and it has to be in accordance with the rules in the transferee state. Such a court can serve the summon and translation can also be made accordingly. Similarly, under Section 29, a foreign summon passed by the court in India which does not come under the Code of Civil Procedure or the court under the authority of central government in India outside India or the court notified by the government in official gazette under this section can be sent to the court under the Code of Civil Procedure for service. Now, modes of service of summon. Summon to witnesses can be served in different ways as it is may serve to the defendant under Order 5. Summon can be delivered personally to the person or his authorized agent. If the person cannot be found in his residence for the reasonable time, the summon can be delivered to any adult family member residing with the witness. The court can serve summon through its court's officer or by the registered post acknowledgement due. This shall be most preferred method as there is a proof of acknowledgement slip and there can be no false report of service of summon. If the person consciously avoids summon and cannot be reached by any means, the court can affix the summon on the door of other conspicuous part of the house where the person resides or on the place where the person carries out the business. Supreme Court recently in suo motu writ petition for the extension of limitation period of lockdown held that digital media such as WhatsApp, Telegram and email can also be used to send summons. It was also held that the blue tick in WhatsApp can be considered as the acknowledgement of the services. Procedure when witnesses fails to comply with the summon. So in this case, witness when fails to comply with the summon served, the person will face consequences laid under Rule 10 of Order 16. In such a situation, it is given that the court may issue a proclamation stating that the person to be present at the specific time and date for giving evidence or to produce the document and a copy of the proclamation has to be affixed on the witness's outer door or any conspicuous part of the house. Along with this, courts on its discretion may also issue a warrant to arrest the person for not appearing. Rule 12 states that the court could impose fine less than 500 rupees for non-appearance, pertaining to which the court could also attach the property of the person in order to recover the fine if imposed. All these consequences could be avoided if the person gives any lawful excuse to the court for his absence. Now, at last, the conclusions. Once the issues are framed in the civil dispute, the parties initially have to classify the witnesses whom they can be bring by themselves and whom they cannot. Accordingly, a list of witnesses consisting of witnesses who can be produced only with the court's assistance has to be made and submitted to the court. Thus, the summons are issued and they should be served on the witnesses in modes prescribed by the statute, by which those witnesses become legally responsible to attend the proceeding. Such witnesses will be penalized if they do not obey the summons and appear before the court. Criminal sanction for the failure to obey the summons illustrate the significance of summons to the witnesses. In a dispute, the witness usually have no interest in the case. They have nothing to lose if they don't carry out their responsibility out of the witness. But a summon from the court creates a liability on a person to whom it is issued, by which the person has to attend unless they come under the given exception. The reason behind such conspecific process is to be obtained a just decision in the end of which. At last, this all is from my side.